Good afternoon, everyone. It's a pleasure to have you here today. And during the topics today, please feel free to make yourself at home for the refreshments. I'm Judge Darlene Byrne. I'm from Austin, Texas. I'm a trial judge there. I'm also the president of the National Council of Juvenile and Family Court Judges. And I am thrilled to have you all here. Thank you for making the time. I want to, one, thank our congressional co-chairs and our partnership organizations that have assisted us in putting this on today. Congresswoman Karen Bass of California. We had hoped she would be here, but I understand it's a little busy up here on Capitol Hill, and my understanding is we're not expected to see her today, but we also are very thankful for her leadership in the area of foster care. We're also very thankful to Senator Cory Booker of New Jersey, Senator Chuck Grassley of Iowa, Senator Dean Heller of Nevada, Senator Patrick Leahy of Vermont, Senator Harry Reid of Nevada, Congressman Mark Amodei, I have to remember my acronym, Amodei of Nevada, and Congresswoman Dina Titus. And for our partner organizations that have assisted us in putting this on today, the Association of Prosecuting Attorneys, the Coalition for Juvenile Justice, the Florida Coalition for Children, Futures Without Violence, the Human Rights Project for Girls, the National American Indian Court Judges Association, of which Judge Blake is our president, the National Court Appointed Special Advocates for Children, the PACE Center for Children, and the Robert F. Kennedy National Resource Center for Juvenile Justice. And before I turn the floor over to Dr. Marsh, he's going to moderate us today, I wanted to just kind of place what we're doing today. How many of you have teenagers at home? If you'd raise your hand, keep your hands up. Teenagers at home. How many of you are still teenagers? How many of you have ever been a teenager? All right. We're going to spend the next 50 so minutes talking about teenagers and how they intersect with the court system and how they intersect in our hope as judges that are trained by the National Council of Juvenile and Family Court Judges on the issue of brain science, childhood development, proper parenting techniques and the like, how we as judges will do no harm to any of the teenagers that come before us in our courts. And with that, I'm going to turn it over to Dr. Marsh.
Thank you, Judge. So I always like to think of teenager, that's a great segue, by the way, is, kind of the court's mission is not to make pathological mountains out of developmental molehills when we think about a teenager. And we have a panel of judges today that are going to talk more about that and how the courts across our nation are doing that work. Real quickly, for those that are not familiar with the National Council of Juvenile and Family Court Judges, we're a membership organization based out of Reno, Nevada. We have a research arm in Pittsburgh, Pennsylvania. Our director here is Dr. Melissa Sickman. And we've been around since, again, 1937. We do training, technical assistance, research, and policy development on anything and everything that touches juvenile and family courts in the United States. So we work closely with judges, but we also work closely with prosecutors, defense counsel, social work, probation officers, detention staff. And I like to think that we really do have our finger on the pulse of what's going on in courts around the country in terms of vulnerable children and families. Today, to talk a bit more about the work that we do, we have a panel to my left. And quick introduction, and when we get around to them, they can tell you a little bit more about themselves. But to my immediate left is Judge Karen Adam from the state of Arizona, Judge Deborah Schumacher from the state of Nevada to her left. The next left is Judge Richard Blake from California. And then you've met our president of the National Council of Juvenile and Family Court Judges, Judge Darlene Byrne from Texas. The format for today is I'm going to give a little bit of context about how we're conceptualizing the work of juvenile and family courts, this idea of a community of healing and what we mean by that. And then I'm going to pose some questions to our panel. And we are going to try to wrap up with 10 or 15 minutes to allow plenty of time for a Q&A this year. That's been expressed in the past that there was more opportunity for that. So that's the plan for today. I'm Dr. Sean Marsh. I'm the Chief Program Officer for Juvenile Law. So the work I do at the Council covers dependency and delinquency and some internal program evaluation. We strive to try to understand what it is that's working with what we're doing in the field. The context for today really goes back about 10 years, I think, with kind of an explosion in science around understanding human development and the adolescent brain. And the judges we work with and the staff doing this work really started to conceptualize there isn't one single point of entry for children and families that touch our justice system. There's multiple points of entry. And if you get past the thinking in a siloed way, that there's themes that run across all the children and families that wind up in front of dependency courts or juvenile justice courts. And we see that there's issues around educational disengagement. We see mental health issues. We see lots of history of adversity, trauma, vocational issues, unemployment, and the list goes on and on. But when you start thinking in this very broad sense of thematic issues that run across case type, we start thinking in a way that the public health people start thinking. We think very broadly. We think that there's no wrong door for intervention. And I'd say out of the last 10 years, at about 5 years back, we hit a tipping point where we started actively exploring this idea of trauma-informed justice, or as Judge Adam likes to call it, trauma-responsive justice. What does that mean for courts? What does that mean for judges? What does this mean for intervention with children and families that come before the judges? And really what we've decided is that the courts are well positioned as a core member of a healing community. That if we think in a public health sense, it's not just a hospital where you go into the emergency room and you get care if you break a leg, but you have primary care physicians, you have community clinics. You have interventions and health presence in schools, school nurses, we have school counselors, and the list goes on and on and on. One of the things that we brought to the table, and I think that we've done a good job at, is positioning the court as part of that healing community. The reality is, and many of our judges say this, and I like the term, is that our courtrooms, particularly dependency and juvenile justice, domestic violence, family law type hearings, really is the social legal emergency room of our country. And we need to be more mindful about the training that we provide judges, the educational opportunities, thinking broader conceptually about what trauma-informed justice is and how we can intervene in a meaningful way to improve outcomes for these folks that become before the courts. So to start that off, and I'm fortunate to have Judge Adam go first because she really has done a lot of this work in Tucson, Arizona, before she retired. And we made the joke a little bit earlier. I'm a lame duck chief program officer, and she's a retired judge. So at the end of this, we're going to say whatever we want and do a mic drop and walk out. So be prepared. Be prepared for Judge Adam here. But Judge, you really have taken this idea of trauma-responsive justice on in a big way in Tucson. And I would love to hear kind of your thinking about what that looks like on the ground from the bench as a judge. I come up from the academic side, you come from actually doing it boots on the ground day to day. What have you learned and what does that look like?
Thanks, Sean. So I think that the most important thing for us going forward today is to define what we're talking about, because we hear the word trauma all the time. In fact, I subscribed to a Google alert on the word trauma, and what was really interesting was that I was also getting reports from hospitals and law enforcement about car crashes and everything. So if you think of trauma as some kind of a major assault on your body, we talk about surgery as being a trauma, and actually you can have traumatic repercussions emotionally and psychologically because of a surgery or some other illness. But if you think of trauma as being in a situation or event that feels life-threatening and feeling helpless and hopeless about being able to do anything about it, that's the kind of trauma we're talking about today. And if you consider then the work that we all do in the juvenile and family courts, the people who are coming in front of us are feeling very, very helpless, often very, very hopeless. And it's so important for all of us to recognize that, understand that, and work with them in that context. So the Adverse Childhood Experiences Study was a longitudinal study. It's actually still going on, developed at Kaiser Permanente by a doctor named Vincent Felitti. And he was able to link work he was doing with patients with obesity with their adverse childhood experience. He just asked the question one day, and it turned out that everyone in his clinic who was trying to do significant weight loss had some sort of a sexual molest or other kind of abuse as a child. And staying heavy protected them. So he thought, wow, why aren't we asking this question of all of our patients? And over time developed this series of 10 questions. So if you're interested and you go to aces2high.org, you can take the test yourself and see. Most of us in the room would score probably at least a 1. And there are things on there, for example, that if you lived in a home where there's a lot of conflict or divorce, if you have someone in the home has been away in prison, if there's been violence in the home, those sorts of things. So most of the children and families that we see, I just thought of this morning, ace the aces. And excuse me for that, but really they score 9 or 10. And you can imagine that if you're at a 4 or a 5, you probably have developed some coping skills and you're going to be able to get by in a way. But if you're coming in with an 8, a 9, or a 10, the degree of things that have impacted you, the assaults on your emotions and your psyche, and maybe even physically for you, are overwhelming. And we need to recognize that about not just the children that we're dealing with, but actually, you know, their parents, their siblings, and their communities even. So for us, trauma is everywhere. It's in juvenile justice, child welfare, which is dependency work, family law, criminal law, domestic violence, probate. I think that all judges need to know about it regardless of what type of law they're doing. And what's really great about the work that we do as judges is what we learn in one area of the law, we can apply in other areas of the law. So when we are able to be trained in these really, really important areas, we take that with us. A lot of judges rotate among assignments and don't get to do juvenile or family or criminal or civil for their entire career. The more you learn, the more you bring with you, the better you are as a judge, the better you are for the people in front of you. And the other important role that we have is that we're teachers. So when a judge is trained and learns about something like the effects of trauma, then that judge is going to be expressing that in decisions, in explanations, in the way the judge is conducting the hearings, in what the courtroom looks like, in how the courthouse responds to people if the judge takes a leadership role, even a small leadership role, like changing what your courtroom looks like. Even one judge in one courtroom can do that. So we are spreading our knowledge, and hopefully everybody around us is benefiting, not just the children and families, but also the lawyers, the probation officers, the social workers, and everyone else. We have to know about it in order to do a good job. It absolutely is critical. And knowing about it has made such a huge difference. I'll just tell you that when I started in 2007 back at juvenile court, I've only done juvenile and family my entire career, so a little bit of criminal, but I came back in 2007 and we weren't talking about it. It's not like trauma's new. You know, the brain science stuff we know now. It isn't that people all of a sudden started having these problems. There's a young girl on my caseload, Destiny, that I just wanted to tell you about as an example. So Destiny, when I started with her in 2007, was 11, and she graduated from the system by aging out of juvenile corrections at 18. And in between, she had 53 placements. She was in 15 different schools, and she had, we now know, much later, been trafficked. She had a terrific and horrific trauma background. We knew that bad things happen to children. That's why we're in the business that we're in. And we had standard responses, but the standard responses weren't right for Destiny. And I wish that I knew then in 2007, and I wish that I could have held everyone around me accountable for knowing the same information in 2007 that I knew by the time I left in 2014 when she was on the run for the 40th time and trafficking. So this trauma information and becoming trauma responsive. And I use the term trauma responsive. James Bell from the Burns Institute said to me, anybody can say they're trauma informed and still be engaging in terrible practices, essentially. If you say you're trauma responsive, and if you make that your goal, it doesn't mean that I'm doing trauma therapy from the bench. It means that I am responding appropriately and requiring everyone around me, hopefully, also to learn about trauma and to respond appropriately. The other interesting thing about Destiny, and one of the other topics for me is girls in detention, or girls in juvenile justice, is that the girls come in with much higher ACEs scores than the boys. And as much work and as many positive, wonderful changes have been made in juvenile justice, for girls, the numbers keep going up. On almost every single category, from arrest to detention to secure detention to probation services, girls' rates are going up by 40 or 45%, which is concerning. And so the system needs to look especially at how that trauma is impacting girls and make sure that what we're doing for services is not just changing out the bathrooms, which is how the system responded early on to girls in the system, but instead to really doing a proper job for girls, utilizing the services that we know work, using the brain science to know what is effective for girls, and then treating them respectfully and recognizing and responding to all the issues with which they arrive.
Judge, how long were you on the bench?
34 years.
Is that all? So you speak with some authority, and just very quickly so we stay on time, we know that hurt people, people that have adversity and trauma in their life, are very, very good at doing bad things to feel better, right? So substance abuse, and I know you've had some experience with juvenile drug courts and that. Just very quickly, what is it you're seeing? What's out there in the landscape of these young people and families that are coming before the courts?
So interestingly, I ran a family drug court myself. I presided over an adult drug court as well before that. So the family drug court was for parents whose children had been removed by CPS because they had a substance abuse problem. And we started doing trauma assessments in family drug court. And someone went and heard Dr. Felitti and came back and said, we're doing it all wrong. We need to be providing trauma work because adult substance abuse is directly linked to an adverse childhood experience. So taking that reasoning, it makes sense that we pay attention to adolescents and children who are using substances. And it used to be that the juvenile drug court model was just the adult model superimposed over children, and that doesn't work. Their brains aren't the same. It's an addiction-based model. It doesn't work. But when you look at it as a way of dealing with trauma and look at co-occurring disorder responses, so recognizing the trauma and the attendant emotional and psychological issues, as well as the substance abuse, take away that it has to be an addiction piece and craft your services carefully, you can make a huge difference.
Yeah, thank you. Outstanding. So, Judge Schumacher, I started off talking about these thematic issues that we see cut across all case types. And what I'd like to do, or like to ask you to do, is drill down a little bit with some of those cases that are particularly challenging. And as a judge, in your experience, I know you've seen them, but what I'm specifically thinking are those thematic issues, the very challenging cases around mental health, particularly in the case of a child, and then kind of dovetailed with that, education and specifically special education, and kind of how those two fit into this rethinking about the role of the court, particularly in a trauma-informed justice system.
Thank you. And before I answer that, I'm just sitting here thinking about the ACEs study, again, the Adverse Childhood Experience Study. If you're in policy making of any kind, juvenile justice or otherwise, I really would recommend it's something that you learn about. The easiest way I found to introduce it to people in my jurisdiction is actually if you go to YouTube and you put in Dr. Felitti or anyone else, you'll get about an hour lecture on, that summarizes the ACEs study, and I think it's probably worth your time. If Judge Adam has whetted your interest as to what the ACEs study might be more specifically about, it's actually pretty easy to get a summary that way. And I've never had the nerve to go take the survey myself. I'm pretty lucky. I'd be okay. So as Dr. Marsh said, I was asked to weave in, drill down a little more with respect to both mental health and then special education.
Judge Schumacher, could you be a little louder? Thank you.
Yes. Is that better?
Yes.
Okay. I'm not going to repeat what I said. If you want to know, find me later. I thought I'd start out talking about, I found over time that sometimes the concrete examples can be pretty helpful. And my home state is Nevada, as was said. And in December and January, the recent December and January, the Las Vegas Sun ran a series of articles on children's mental health, including a number of them on juvenile justice and mental health. And in those articles, the readers learned of a young man who was called Colby for the purposes of the article, and who appeared in front of one of my colleagues, Judge Voy, and I've talked to Judge Voy about this since reading them. And Colby had been and is diagnosed with autism and some cognitive and other behavioral disorders, and he found himself in front of the court because he had been he was accused in any event of running down the street, pelting cars with rocks, and also trying to physically injure his mom. In the prior 6 months, he'd landed in the University Medical Center pediatric department more than 25 times in 6 months. And the pediatric department didn't brush him off. They were so concerned that in fact one of the physicians from the University Medical Center was in Judge Voy's courtroom trying to help and assist figure out what to do. And I think almost anyone would say, this young man probably doesn't belong in front of the juvenile bench. I mean, he should be plugged into mental health. But as Dr. Marsh alluded to, people with mental health issues will frequently behave badly. And if they behave badly enough that they're injuring others, we're going to have the inevitable intersection of the juvenile justice and the mental health systems. There's no way around it. So I'd like to say, shouldn't be there. But if the young man's destroying property, the real world is he will be there. So now let's figure out what the right thing to do with those circumstances that we can't change. I wish I could tell you that there was, for Colby, a good outcome. There's not been a good outcome. About 15 adults were involved in trying to figure out where this young man could be safely placed. No one would take him because of his unique problems. He wanted to go home. His mother wanted to have him home. He was released home, ultimately harmed her again, and was back in front of the judge, and that case is ongoing. Readers of that Sun series were also introduced to a more hopeful case, a young man who had committed domestic violence against some of his family members in his home, came in front of the juvenile court, and the juvenile court had him assessed and ended up requiring the family engage in family therapy that happened in their home. And that young man also came back in front of Judge Voy, but in that case, at least the last status update I had, the family all said things are better. The therapeutic intervention is helping control the aggressiveness. We seem to be finding a way to tamp down and to work with and to get at the problem that brought this young man before the court. An hour in any of our juvenile courtrooms would teach a humbling lesson of the complexity of these cases. Sometimes when there are judicial confirmation hearings or elections for judges, you'll hear, is it like balls and strikes? Do you just, apply the law? Well, if that's what you want, juvenile law is just not your venue, because it's not that way. There's no way it can be. It's complicated, it's messy, it's frustrating, it's sometimes hopeful, and it's always very human. Maximizing public safety, assisting children to move toward productive lives, employing juvenile justice solutions that we know work from real data, safely reducing incarceration, which then also reduce taxpayers' costs. These are actually goals that are really one of the few things I can say in the current climate are supported in a bipartisan way across both sides of the aisle and across many professions. Almost 2 million youth are arrested each year in this country. Of these, 95% are not accused of violent crime, but 60 to 70% of them have one or more diagnosable mental disorders. And the current literature suggests mental health disorders in the juvenile justice population are perhaps about 3 times as the rate that they are in the general population. In this context, a minimally competent juvenile court judge needs to be a bit of a Renaissance judge to know all of the things that Judge Adam was describing. It's not enough to know the juvenile code, and it's not enough to be thoughtful and well-meaning. You need to be acquainted with the basics of adolescent development, of addiction, of mental health disorders, of your community resources, their availability and their quality. You need to keep up with the findings of research regarding evidence-based practices and what works. Because, you know, we've learned to our sorrow that common sense doesn't cut it. I can remember when I began, and I think all of us who sit on the bench for a while have shared with one another, could we hit the reset button? Every one of us has cases in which we wish we knew now what we knew then. All we can do and all anyone can do is go forward. But we've learned what appears like it ought to work doesn't necessarily work. How many times parents would come to me in my early days in the 80s, I hate to say, in the 90s, as a juvenile magistrate and say, you know, I don't want to pick up my kid tonight. I want him to stay in detention. I want him to learn. He continues down this road, you know, essentially a version of Scared Straight. Well, when I was new, that didn't sound ridiculous. What's one harm of a night in detention? Well, there's a lot of harm, and that's what we've learned from data. One night in incarceration for a juvenile makes it more likely that that young person penetrates the system. That's the kind of information that juvenile judges need to know. They need to have very specific education. The young people will come in front of you, and the question is, as was stated earlier, are you going to do harm, or are you going to get the tools, the information, the education you need to try to put this case in the right way? And ideally and crucially, in my opinion as well, as taught by the National Council to those of us who engage in their education, the juvenile judge needs to use his or her convening power. Fortunately, the real world is if a judge calls a community meeting, people will come. That doesn't say they'll keep coming unless you give them something that makes their time worthwhile, but usually they'll come the first time. And so if you can bring stakeholders in my county, which is the northern part of Nevada, it was a judge, Judge Francis Doherty, who was responsible for sparking the community's interest in the Juvenile Detention Alternatives Initiative, which has reduced safely in my county incarceration rates for juveniles about 50% without any rise in crime. Our system didn't do the heavy lifting, but we were responsible for engaging the stakeholders, for inviting them again, for keeping them with us as we went through it. Similarly, I was involved over a multi-year, more years than I care to admit, process of the creation of educational protocols so that juvenile judges would know whether kids were in school and how they were doing in school and how we would work to keep them in the same school even if they were in foster care, if that school had been part of their positive experience, and get the information if, you know, in this child's case, we really need to move them. Well, without those protocols and that information exchange, the judge is potentially allowing that child to be removed from the one environment that might have been the most positive thing in his or her life. All of that takes work. All of that requires judges who understand why they need to do that work and how to do that work. The federally supported programs that offer the training necessary for the kinds of things I'm talking about, a competent judiciary, are the Office of Juvenile Justice and Delinquency Prevention's Child Abuse Training for Judicial Personnel and OVW's grants to support families in the justice system. Juvenile judges are stewards of both human lives and taxpayer dollars. It requires the holistic approach that Judge Adams was describing to do that work right. I have no idea how I'm doing for time.
You're about there. So,
Okay, so let me take 2 seconds to
Absolutely.
touch on education. In many ways, children in special education are a bit of a continuation on the theme that I was talking about. They have very unique needs. If it is at all possible to meet those needs without detaining them, there is no database to assume that detaining a child who is acting out in school because school is a place of failure for that child without understanding why the child is acting in that way could anyway begin to pave anything other than an unsuccessful future. I really have more to say. I apologize I didn't say it.
No worries.
Thank you, Dr. Marsh.
Should I ask Judge how long you've been on the bench, or would you prefer?
No. I actually, it felt like the 80s, but it was really November 1992.
So to the point of mental health, I think that one thing we need to be aware of, and Judge, you touched on it, is this idea that if the judges aren't well educated and knowing what they're looking at, the juvenile justice system becomes a proxy for psychiatric psychological care. And we see again and again in the data, a colleague of mine in California looked at deep end kids that have gone all the way through to, kind of past detention into corrections, and about 90% they found had post-traumatic stress disorder, which is a diagnosable mental health issue, and about 60% had some other diagnosable mental health condition. When you start looking at relative populations, and Dr. Sickman's an expert on that, that's called overrepresentation in a big way. So we see evidence right there that the juvenile justice system is serving as a proxy for good mental health care. And to the education point, and to transition into Judge Blake, really this idea that education is life-saving, in that once judges and courts can appreciate the importance of keeping kids in school and out of court, it becomes incredibly critical to constantly have that kind of on the forefront of the work that you do. And Judge Blake, not only are you judging in a tribal court and have a unique perspective on the tribal court work and disproportionate minority contact, that overrepresentation piece, but also you've been very active with the council and other sites across this country on that very topic of keeping kids in school and out of court. So my question for you would be, what sort of perspective do you have as a tribal court judge on the work around this community of healing in a very broad context of keeping kids engaged with education, that it is life-saving, and that issue of meeting communities of where they're at in terms of culture and how that dovetails with courts? And I apologize, that was a double-barreled question, but in the sake of time, I'm going to turn it over to you and let you go for it.
I appreciate that. First, I have to address Judge Schumacher's issue with the idea of bringing people together and finding a way to do that. I did that by providing Indian tacos, and I'll tell you, the second time around, there was a room full like this for the second round of Indian tacos. So where there's food, they'll come. My name is Richard Blake. I am the Chief Judge of the Hoopa Valley Tribe in Northern California. I also sit contractually for the Redding Rancheria Tribe in Redding, California, and the Tolowa Dene Nation in Smith River, California. The Keeping Kids Out of Court and In School initiative came after my election in 2002, when I was asked by the high school principal to speak at their high school graduation. I looked at their stats as just for some unknown reason, and realized that they only had 33 graduating seniors. And I'm thinking, how many incoming freshmen did they have 4 years earlier? I started looking back at these records and then realized that when you have 115 incoming freshmen and you have 33 graduating seniors, that's not a good record. That's not a good record. Where are those other kids at? And what is happening with them? Where were they? They were in my drug court. They were in my dependency court. They were in my delinquency court is where they were at. And so I was seeing those kids without them actually being in a school setting. So it took several years for this to finally sink in, that these children were not lost. I knew where they were. I just wasn't looking in the right place. So what I had done is the National Council actually did have this initiative, the Keeping Kids Out of Court and In School initiative, and I looked at that and I thought, wow, this is where I need to be. This is what I need for my community. So I took that initiative, I applied, we were actually granted this ability to participate in this, and we did receive some technical assistance. I brought together a group of people, educators, I brought together parents, I brought together all these people, and the one person I didn't think about was a student representative. So I brought 3 in, not one, I brought 3 in. And out of that, we heard some of the most dynamic information that I have ever heard. It's what they needed. I needed to hear from them what it is, how we were going to keep them in school. And what they told us is school is not a place that they felt safe. School is not a place where they felt that they could go and learn. School was not a place where they felt that they could fit. So we as community representatives had to find out what it was that these children were afraid of. What we found out is the majority of these kids on the very first day of school did not have the school clothes necessary to go to school. They didn't have the shoes to go to school. They did not have the school supplies to attend school. So as a result of that, what we did is one of our programs gave away backpacks. Our responsibility was to get the supplies to put in the backpacks. And on top of that, and setting those on a pair of shoes so that those children are at least getting a first step in the right direction to school. So we give the children that opportunity, give them the opportunity to have a fresh start in a school year. So little by little, we were seeing a decrease in a number of delinquency cases that we were hearing. Was it that the children weren't being cited? No, we were finding alternatives to keeping them out of the court system with a diversion program, meaning that instead of trying to find detention beds for them, we were making certain that the probation officer was keeping them in school by making certain that they were attending every class every day on time and maintaining acceptable grades, behavior, and attendance. So that was their job. And with that task in mind, these children then made the goal to attend school and to become a productive community member. We also have to realize that a majority of these children suffer from, come from homes where there is a economic deficit in their home, meaning that they come from homes that are well below poverty. Unemployment rates on my reservation is extremely high, and I'm going to say it's well in the area of between 50 and 65%. So it's quite high. It's quite high, and you'd think that shouldn't happen in today's society. It does. It does, and these children are living proof when you see them that this happens. When you see a child come in by themselves into a court setting without a parent because the parent is either unable because of some type of substance abuse issue or just lack of compassion and lack of care, they just don't come. And you have this child who is motivated themselves to come in to this court hearing by themselves. You have to give them their attaboys for that because, one, they're there. My commitment to my community was, one, that I was going to find a way before the end of my term. I have 2 years left in my fourth term as their chief judge, and the ironic part is last year they asked me to speak. I haven't spoke yet because we haven't reached that threshold. I said 70% or better. And I will say last year was the first year that we were pretty close. And yes, and I'm thinking that in the year 2016, the graduation in June of 2016, this chief judge will be standing on a stage at the high school graduation, finally giving that speech. And out of that graduating class this year, I told them that what I have done personally is develop a scholarship. The tribal youth that ends up in a Cal system school in the state of California that comes through the court system will get this scholarship, and I will continue to fund that until they make it through undergrad at least. I mean, I can't go beyond that because I have a child of my own, but it is my commitment to my community, and one that I think that all of us as members of this country need to understand that this is only unique to the Hoopa Valley Indian Reservation. There are several other communities out there. You don't have to be a reservation. It could be Judge Schumacher's court. It could be Judge Adams' court, Judge Burns' court, that these youth are there. These youth are making these struggles daily to make it to school, to make it to keep themselves out of this court system. Dr. Marsh talked about the prison to pipeline, the school to prison pipeline. It's true. I've had those kids. I've had those kids in the prison system, and it's very disheartening to think that I failed them because they should never have ended up there. They should have had the same opportunity that I'm offering to these youth today. But without the educational opportunity that the National Council gave me, I would not have known. I would have not known that this was something that is so vital to keeping our kids out of that system and keeping them on the right track to a healthy lifestyle. And the funding for this type of programs needs to continue to be funded so that not only this tribal judge, but all the tribal judges that sit in the 563 tribal courts throughout the nation are also going to benefit from.
Thank you, Judge. And one of the things that I've personally really enjoyed working with the tribal courts, which we've been doing increasingly over the years, when we talk about communities of healing, how much we have to learn by visiting our tribal courts and being involved with judges like you, peacemaking courts and restorative courts, just have so much to speak to about what we're trying to accomplish with our trauma-informed
Right.
justice.
And one of the things as Judge Byrne had indicated, I am the president of the National American Indian Court Judges Association, and those are the opportunities that, in conjunction with National Council, that we are trying to partner and provide those training opportunities for the nation. And those go beyond just tribal courts, because those go to a collaborative of tribal, state, and federal judges.
Right. Thank you, Judge. Judge Byrne, you're our cleanup for the panel today, and have probably the most daunting task in some ways, because I have a triple-barreled question for you. Not really. In thinking again of these thematic issues, one of the challenging populations with whom we work are dual status or duly adjudicated youth. And for those that aren't familiar with the terminology, that's kind of one foot is in the foster care system or child welfare system, and one foot is branching over into the juvenile justice system, and they're in this odd sort of crossover position. So that's one thing I want you to try to incorporate into thinking of this larger community of healing, but also to speak to the valid court order exception in the Juvenile Justice Delinquency Prevention Act, which is kind of focused on status offenses, which we know is kind of prime territory for the crossover kids. And then really the big carry for this, because it is such a hot issue and we've been involved in it, is child sex trafficking. And how is it that these three things kind of coalesce around each other, which may not be obvious to folks that don't do this work, but you see it every day. How does that all work together, those three things?
Oh, thanks for the question. I want to first, before I jump off into that complex question, is when you were a teenager, did any of you violate your penal code? Did any of you skip school? Did any of you run away from home? Did any of you steal something from a store? Did any of you steal something from a teacher's desk? I would venture to say, if you didn't do it, your brother or sister did. Probably they did it, obviously. But maybe you didn't get caught. Well, the kids that we're dealing with in juvenile justice got caught. And sometimes the things that they got caught doing are the very same things that you did as a teenager. So I want to place it with that lens. So we're dealing with everyone in this room. You could have gone through Judge Byrne's court back in the day, and I hope that I was a Judge Byrne that was trained by the National Council, because my thought process would be do no harm to you in that process. I do preside over all the children that are dually involved in my county. I also preside over all the child welfare cases. So dually involved, again, is they are simultaneously in the juvenile justice system at the same time they're in the child welfare system. As you might imagine, that is a complex needs group of individuals. Many of those individuals are away from their parents. They've been away from their parents. Many of those individuals do not know who their father is, or if they've ever met them, it's been behind bars, or that individual has never paid one dime to put a piece of food in their mouth or put a piece of clothing on their back. So let's talk about the ACEs study. These kids really did ace the ACEs study. It's very traumatic. I'm going to share with you through the eyes of two kids in my court, in my crossover court, where all of these things that we've just been talking about intersect. And unless you're trained, you don't recognize it. And unless we, as a body, a policy-making body, do not reauthorize the Juvenile Justice Delinquency Prevention Act, shame on us. It's been since 2002. So is that what we as a policy-making body want to tell our young people in the next decade? That we don't value you enough to even reauthorize the JJDPA? That's what it says to me. And we've been behind the 8 ball since 2002, and it's time to make a difference. And it's time to make a difference for these 2 young people that I'm going to share with you. I call them success stories. The definition of success in my court changes every day. And I want to talk about Katie and Amy, and these are not their real names. I'll start with Katie. Katie is a young lady that is still on my docket today, and 2 years ago in this same room, in this same briefing, I talked about Katie. I would not have known that I would still have Katie on my docket today. Katie was on my docket. I had about 15 cases in the morning on a Thursday morning crossover docket. Katie was about the 3rd or 4th. Beautiful African-American, tall, 14-year-old, articulate young woman. Stunning. Her grandmother was in the courtroom with her, should have been in a wheelchair. She was very, very physically impaired. Her mother was nowhere to be seen. Dad has never been seen. He's been missing in action for a long time. I have no idea where he is. Mom struggles with abuse of drugs and has for many, many years, has her own history of trauma. When Katie stood before me, all I'm trying to determine is whether I detain Katie or not. That's what I'm trying to figure out. Well, in my 15 minutes with Katie, I found out that Katie at 14 was pregnant. I found out that Katie's baby daddy is in excess of 20 years old. In my state, that's statutory rape. I also found out that Katie has yet another child who is already in the foster care system. So in one hearing, I'm concerned about where's Katie's baby daddy? Where is he? Has he been arrested yet? I want to know, I want you to tell me where he is. So I've got the makings of a criminal case. At the same time, I've got the makings of a juvenile justice case. I already have a child welfare case and all the signs in place that young Katie was being trafficked. All of those things I found out in 15 minutes. Now, I'm an old business lawyer. I used to do fights over money. I did not learn this in law school. Where I learned about the signs that I was seeing in Katie's case was through the work I did with the National Council. So if we don't educate judges, what if I had missed the fact that I've got a potentially trafficked child? Would I have brought in the sex trafficking task force in the state of Texas to start working on that case for Katie? Probably not. What would that mean? Yet another Katie being victimized in Houston, in San Antonio, in my town, in your state, your community. So it's critical that the judge at the bench has got all the tools available to them and the education available to them to see the signs of abuse, neglect, being trafficked, all of those things, and the needs for that baby and that mom, that teenage mom, to learn how to be a good mom. Now, Katie, you're wondering, why is Katie still on my docket? Katie has been missing, I don't know how many times, 10, 15 times. Get her in a place that deals with sex trafficked youth. Send her back to grandma. Send her to her mom. Try to work with her mom in drug treatment. Send her to her mom. Once she got, it stopped traffic that morning in Austin, and I was listening to it as I was getting ready for work. And I knew that traffic on I-35 was stopped, and I found out that what had happened was Katie had gotten picked up at one of her places. She hung out at a corner store, got picked up by these bad guys, and they dumped her out on the side of the road with her head bashed in with a baseball bat. So she was in the hospital for, I don't know, a month and a half to rehabbing. So now I've got a brain damaged child in addition to one that is preyed on by sex traffickers. She keeps going away. I keep finding her. And she keeps going, Judge, I don't know why you care. And I'm like, Katie, every time you run, I'm going to send somebody after you. Every time. Until you figure out that you're worth something. To me, if to no one else. But Katie's missing right now. So we've got people looking for Katie right now. Now, on the other hand, I'll tell you about Amy. Amy was under a bridge with her grandmother and granddaddy at 14. Amy's beautiful Caucasian girl with dreads. She'd been selling her body to feed her grandmother and her granddad and herself. Her mom had been in prison since she was 2. She's 14 now, so she doesn't know her mom. Her dad also MIA. We never have seen Dad. Most courts, she came across my juvenile court, and it was for failure to ID. Oftentimes, sex-trafficked young people get brought in for failure to ID or shoplifting, and that is how the precursor to get them to services. We picked up Amy, and she showed up in my court incredibly articulate, incredibly bright, very frustrated with her hair. It gave her headaches. I finally got a surgeon. I could have a surgeon go in and shave her head. She promised me she wouldn't be mad at me. And today her hair's all grown out. She looks beautiful. Brilliant young woman, hadn't been in school for 2 years, ravenous reader. So we started feeding that fire. I started buying books, sending her books. And ravenous reader. Her mom finally got out of prison. We reunified her with her mother, who's been in prison since she was 2. She graduated from high school at 16, and the last time I saw her, she was enrolled in college at 17 years old at home with her mother. Most families would have thrown away the mom, not realizing that this young girl is going to go look for that mom after she turns 18. So if I can heal that family while she's in my court, I will use every family resource I have at my disposal and work with them to try to have that child have a sense of belonging. Now the VCO. Running away and being truant is a status offense. You've heard that term. The valid court order exception is inside the JJDPA Act. That was back in 1980, where we thought it was good to lock up kids that run away and are truant. If they're 18 and you ditched your high school class or you ditched your college class, you're not getting locked up. If you run away at 18, you're not getting locked up. But if you're 17, 16, 15, it might be if you violated a valid court order under the present state of the JJDPA Act. It's shameful. We know in this country, 35 years after the first JJDPA Act, that children's brains are not developed until they're 25. So guess what? They do stupid things. They put themselves in harm's way. They thumb their nose at rules, their mom and dad's rules and the court's rules. So we need to build a better system to take care of their needs. And that's the end of mine.
Perfect. Thank you, Judge. And in the sake of time and staying on schedule, wrapping up at 3 o'clock, I want to make sure we have time for questions. So this is the so what, right? What are we having the briefing? What can you do to help us? And what we need is federal support. We need federal support in 3 primary areas. As Judge Byrne noted, we need to reauthorize the JJDPA yesterday. It needs to happen. It's well overdue, but it provides the core requirements and kind of core protections that we want to see. We also are asking that we continue to fund OJJDP's child abuse training project for judicial personnel and practitioners. That's what allows us to have great judges like this panel and many other judges in this room, a well-educated judiciary. And lastly, we want support for the Office of Violence Against Women, grants to support families in the justice system. And the 2 last funding streams that I mentioned are a primary source for the educational funds to educate our judiciary. And it's critical to achieve these community healings that we want, and again, to push out evidence-based practices or practice-based evidence, as Dr. Sickman likes to say. It can be done and it's critical, but those are the 3 big things that we need federal support for. And with that, I'm happy to open it up to any questions you might have for the panel. Yes, in the back, please. So I'll start off and I'll turn it over to the judges. The second part of the question is it's one of the most common recommendations we make in doing trauma consultations with courts was exploring alternative docketing practices so you're not inadvertently penalizing people for having a job, you know, those kinds of things, right? And there's some practices here that I think the judges can reflect on. To your first question, yes, absolutely. And one of the philosophies we have is judge-led collaborations, and that includes judge-led training efforts. So we bring together defense counsel and prosecutors and probation to make sure they're getting the same message as the judges. We use the convening power of the judges to do that. I don't know if David's here, but we work with Association of Prosecuting Attorneys. We also work with National Juvenile Defender Center to do exactly those kinds of things so that the voice of the judges is trickling out to the professional standards and expectations for defense counsel and prosecutors. I don't know if any of you want to add anything to that.
I just want to add really quickly that we became a trauma responsive court. We started in 2012, and a part of it was training each of the various professions separately. First on vicarious trauma, so they would recognize the effects of being exposed to this all along, and then also on how to respond to their own clients, whether they were probation officers or detention officers, prosecutors, public defenders. They're all part of our group, but everybody got the same training, and then they did train the trainers and trained within their own offices, trained their support personnel and so forth. It's really, really critical, as I mentioned before, that the judge leads and then hopefully everybody follows, and what the judge teaches is hopefully carried on. It's really important that everybody who is touching the life of a child or a family be speaking the same language and be responding the same way. Yeah, really important.
Also, the use of technology with regard to hearings is a great way to let people be at their jobs and them take a telephone break or some type of video break and attend that way.
And I would just add, if I could, we certainly train everyone also, all stakeholders, but I wouldn't say that it's always easy, especially when new prosecutors come in or others, you know, they come from a different system. But what we have succeeded in doing is just with persistence, ultimately sort of breaking it down. But I wouldn't want to suggest that it's smooth. I mean, if folks who come in, you know, to the wherever they come from have usually come from a very adversarial way of dealing that is so different, but the culture has ultimately prevailed.
And one of the other things that we have done is night court. We went right back to the old the old school, went back to night court so that if a parent is unable to attend because of childcare issues, because of work issues or whatever else, we offer night court one night a week. And I'll tell you, you know, night court sometimes fills up quicker than daytime court. So it is, because we see that parents are more productive in the evening time when they don't have the younger child care issues, and perhaps the student and the parent can attend together.
So there's another question. Yep, you bet. So we have a question back here. Before we ask that question, I understand if people have other appointments, we were booked till 3. If you need to leave, that's fine. Before you do, could I just ask any of the member judges that are with us on this trip just to kind of raise your hand where you're at. If you have questions, everybody with their hand up is a judge and participating with this. Feel free to grab one on the way out the door and ask them their questions. And I'm happy to take your question, ma'am.
Great. So that was really a very moving presentation. Thank you very much. I am in D.C. now, but I lived in Montana for a long time, and I know how hard it was to get treatment resources, especially for young people. And I'm wondering if you have struggled in your courts to get for trauma-informed care, mental health, substance abuse treatment providers, and how have you overcome that?
Yes. You know, it's common, and the judges can speak to it better than I, but in traveling across country and working, that is a huge issue for every jurisdiction. I don't care how big and how wealthy they are or think they are. But what I teach when I think about trauma care, trauma-informed justice, is if you've heard the phrase, there's a death by 1,000 cuts, well, there's healing by 1,000 Band-Aids, right? So every point of contact, every last point of contact is an opportunity to promote healing, all the way from security personnel at the front of the court, all the way through the judge, et cetera. And when you start thinking in that public health model, it becomes much less daunting to say, I don't have 48 PhDs at my beck and call to meet with this clientele. But any creative suggestions or thoughts?
I think the same thing that we've been talking about, the power of convening and bringing your community together, having a call to action to your community. It's, we've done numerous editorial pieces in the newspaper, a call to action to a cohesive mental health array, a cohesive trauma-informed, evidence-based therapeutic models throughout our community. We are now kind of birthing and seeing the place related to minor sex traffic victims. Their needs are very, very different. We've got a lot of service providers after adjudication, but we're wanting to do all of that work pre-adjudication. And so right now, what our community is literally building as I speak are building beds and resources and community-based resources for that. But it really is a convening power of the court, and lots of rubber chicken and lots of ham sandwiches,
Engaging persons of character is another, finding that person thinking broadly about judges, probation people, the neighbor next door that likes to build Harleys, the whole list, coaches, teachers, they're all resources and those positive, very important non-parental adults that can really change the course of children.
And in California, we are doing the collaborative between the tribes and the state too, so that those are even more resources that are available to one another.
And this is really down in the weeds, but I attended a presentation by the Veterans Administration a couple years ago about how they were attempting to provide medical care in these areas in which doctors weren't present. They were doing things electronically that we never thought to do, sort of Skype. And so we're actually exploring that in our jurisdiction because parts of Nevada are so rural. I mean, there is not going to be the psychologist in that county. There just isn't going to be. So how are we going to deal with it?
So I think we're going to have to wrap up. If there's any last questions, we'll be here for a bit. Feel free to come on up and ask us. We're happy to serve as a resource. I did want to mention that if you're interested in juvenile justice issues or know folks that are, our national conference on juvenile justice is in March in Las Vegas. Mary Kay, shout out the dates. I'm trying to remember the dates. March
20, 21, 22, 23.
21, 22, and 23. So it's a national conference. We bring folks together and touch on a lot of the issues we touched on today. It's across all disciplines, right? So to the question in the back. Well, I want to thank the panel, Judge Adam, Judge Schumacher, Judge Blake, Judge Byrne, and thank everyone for coming. We really appreciate your time. Thank you.